Dear beloved Creator of all that is, we call you when we face challenges, and we are fortified. Our spirits are buoyed by right action, and you fortify us. We ask for divine wisdom in all that we do, and it is given. We are humbled by your presence, and we are graced, and so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. Notice of intention. Caveat to will. Probate the claim in open court. The claim. Violation of due process. 18 U.S.C. 3571. The number to be determined by verdicts and awards to pay damages. $250,000 per violation penalty award. By way of an example, Article 3 judges making judgments into Article 1 courts when that is the prerogative of the court. We have had that Article 3 one Supreme Court claiming original jurisdiction on Oregon since 2018. Found in our Amendment 7 Civilian Common Law Court of Record. That court is dated 2018. The Fifth Appellate and SCOTUS determined in SEC versus Jacarcy 603 U.S. 109 2024. The court we created on Oregon is the one needed to correct the administrative courts, Amendment 7. It is courts that determine law and judges, It is the courts that determine law and juries that judge the facts. Judges attend to cases less than $20 in a constitutional civilian common law court of record. We made that court several years before that decision, 2024. We have the land and soil, original jurisdiction, venue, and law form, Jural, on Oregon. A court is 3 tribunals, a clerk with a marshal. All of us are jura summa imperii. In a civilian common law court of record, law is identified as Oregon's Constitution, circa 1859, the United States of America's ' Constitution, circa 1859, Bouvier's with an ' Law Dictionary, 6th edition, 2 volumes, 1856, published specifically for this task, available on Amazon. It's printed in Troutdale. The nomenclature starts with province, page 437, Bouvier's 1856. It is the province of the court to judge the law, that of the jury to decide on facts. As recently decided and affirmed by the Fifth Appellate and SCOTUS, that it takes Amendment 7 required and Article 3 recommended in SEC versus 2024. On Oregon, when we have Amendment 7 from our Bill of Rights, Jural, we cannot have Article 7 amended. Article 7 is all caps. From the current Oregon Constitution, original jurisdiction is required in Article 3. Men or women with their progeny goes against the state, it takes an Article 3. We have a civilian common law court of record on Oregon. We also have a grand jury. In suits in common law, judges decide matters of less than $20. Therefore, as our Article 1, Section 1 social compact on Oregon, We are the provisional government on Oregon, aka Oregon Statewide Jural Assembly. Through ex parte Milligan implementation, there is no martial law, Labor Code, FEMA on Oregon. November 2022. With Article 3, our one Supreme Court claiming original jurisdiction, and Article 7 original jurisdiction, Article 7 in Amendment 7, whose verdict has no appeal in fact. There really is an active conspiracy. The industrial, military, judicial, legislative, executive, banker, Masonic, bar, royalist, Nazi, communist, jihadist, Catholic, Jesuit, Khazarian, UN, Big Pharma, medical conspiracy complex, minus the Georgia Guidestones. Did you take the jab? We did not. They did, allegedly. They are looking to create a different de facto governance, not return to a constitutional Article 4, Section 4 Republican form of government. Donald John Trump, Elon et al. Are looking for a soft landing. Take a look at the group he has put together. RFK Jr. for one. The truth is not released on JFK, RFK, MLK, 9/11, COVID-19, and on and on. Maybe yes, maybe no. Is there gold in Fort Knox? I read there is more gold accounted for on paper as deposits in bank vaults than has ever been mined. This is analog. It's not digital. We must do it ourselves on each state and each territory. They are saving their habitat. Their habitat is the United States of Washington, District of Columbia, Inc., forts, ports, and needful buildings. We are doing Oregon. Are the sheriffs saving their habitat? The Salem oligarchy since 1910? Their goal, by their actions, is still the same. Remain in control and control the left a little more and get the same results from the right. We cannot do it alone. www.orsja.org is Article 1, Section 1, original jurisdiction of Article 7. Article 3, Amendment 7. Article 4, Section 4. From June 2018. Several years, and we're still standing. Without rebuttal. Pragmatic persons are willing to compromise their integrity and our freedom, peace, safety, and happiness, our unalienable rights, and due process as codified for our founding documents for their best interests. So, are you pragmatic or honorable? Would you lie to save a good cop? You know, one that only violates the rights of bad guys. That's not rhetorical. That is a key. If you have to lie for him, he's in the wrong job. So are you in the wrong job. Taking the proper oath and bondability to the correct constitution with the laws of nature and nature's God included, then you must have the honor of your oath and keep it. Or move on. We will have Jural as required by 2 constitutions, oath and bondability, DPSST, ORS 206, county HR and recorder, the proper bona fides. When you agree, and I think that the U.S. DOJ, U.S. Marshal Services, the courts, Department of Homeland Security, FBI, et al., and the Secretary of State, Oregon State Police, Departments of Correction, and the Oregon National Guard should accompany the sheriffs in taking a proper oath to the proper Constitution, with the laws of nature and nature's God included. And I yield.
Number 3. Sheriffs, one and all, the ball is in your court. We kicked it into your jurisdiction, which is separate from ours, alas. It really is one team, you and us. It is, or rather should be, one jurisdiction. Your training, probably from childhood, has been to join the realm of the corporate jurisdiction, which is the entity that pays you to do what you do. You can join our team, that of the people, with a simple turn of a mind switch. A tool to assist in this process is to consider taking a proper oath to the proper Constitution with its original jurisdiction and with the laws of nature and of nature's God, as stated in our unanimous declaration of the 13 United States of America. The last several months, we have posted and made publicly available what we consider a proper oath for the persons in our governance. Sheriffs are our first effort at insisting on a proper oath, for it is the sheriffs who are in their county position to protect and defend the people from ticketing or sending people to the illegitimate amended Article 7 courts that should not be, and from government overreach and taxation that takes seniors' equity, their forever home, and all they possess by enforcing convictions. It is like a shift in the mind. It is a recognition of one's allegiance to life and that which is God-given, rather than criminalizing living God-made beings or a dead corporate entity. Our sheriffs are our first protection against governance overreach and a system of governance overreach. Taking a solemn oath is needed for there to be remedy in our authoritative system of governance. Once a sheriff cognizes the importance of the proper oath, they can see themselves as one of the people, one with the people, rather than a corporate entity meant to enforce our compliance to the bidding of the state. Therein is offered greater freedom, cooperation, and peace in all our dealings. Let it be so. I yield.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is Subpoena the Sheriffs. Let's fix this. Subpoena ducis tecum and subpoena testificandum. The basic original jurisdiction source materials are Oregon's Constitution circa 1859 and the United States of America's Constitution circa 1859 with Bouvier's Law Dictionary 6th edition 2 volume 1856, governing law and the dictionary for definitions. Then provide these subpoenas to those that are and should not be, such as 36 sheriffs on Oregon, 38 Oregon prosecutors, 36 DAs, 1 Attorney General, and 1 JAG for the National Guard. Article 7 amended judges without good behavior, proper bona fides, oath and bond ability, Oregon State Bar, Oregon State Police, Oregon National Guard, and the Department of Corrections are all without bona fides because they cannot meet or exceed the standards required. They must comply to an audit of their bona fides or vacate the office or position. Our civilian common law court of record will assist anyone in fulfilling their obligations and responsibilities. We have the solution, at least a solution. Our court is the nomenclature, and it starts with province, page 437, Bouvier's 1856. It is the province of the court to judge the law and of the jury to decide the facts. As recently decided and affirmed by the Fifth Appellate and SCOTUS, that it takes an Amendment 7 required and an Article 3 recommended in SEC versus Jacarcy 603, United States 109, 2024. The exact civilian common law court of record that we have on Oregon. A complete and common understanding. It is all written down, and we and you need no opinion from legal. Find unfettered counsel. This is your oath and your contract with Article 1, Section 1, Article 3 with original jurisdiction, Article 7, Amendment 7, Civilian Common Law Court of Record. See the Chevron and SEC Jacarcy. Signed, sealed, stamped, witnessed, proof of service, and published on 3 cable TV channels, YouTube and Brighteon, and www.orsja.org. And we've been doing this for 7 years without rebuttal, one step at a time. That counts. Courts decide the law and juries judge the facts. We have that court and jury. We need our sheriffs. See Bouvier's Law Dictionary, 6th edition, 2-volume, 1856, available on Amazon, and it's printed in Troutdale, Oregon. The United States of America's Constitution, circa 1859. That's law. ORS 206, DPSST, Oath and Bondability, Country HR, and County Recorder. Those are requirements. Once your jure sheriffs are in place and the proper papers may be served, informing the Secretary of State, the Department of Corrections, Oregon State Police, and Oregon National Guard what is required constitutionally, provisionally, until proper elections can be held. That takes a proper Secretary of State and Deputy Secretary of State. Our civilian common law court of record is researching subordination of perjury. Page 607, Bouvier's 1856. Investigating the existence of Article 7 amended in de facto, incorporated color of law recooperation of the Oregon State Bar and or its members, including the judiciary. Additionally, good behavior is the key. Self-correct with the proper oath. Using this position with Article 7 amended is proof of not good behavior. We are no longer deceived. The claims are made and published by each of you named and for the office you claim. Provide your bona fides of office. You all make the claims of who you are, how you have the authority, and each is held to a published requirement. It's a standard. We have found no evidence of your claims, Article 7 amended, and all the ORS about the Oregon State Bar. Caveat to will and probate in open court. Prosecutorial discretion is extensively practiced to deter action against the state and its bad actors. Article 7 amended de facto by definition. In common law, the principle of prosecutorial discretion allows public prosecutors a wide latitude to decide whether or not to charge a person of a crime and which charge to file. The Bar, Guild, PMA, Attorneys Union, ABA, Esquires, JD's Association of the Oregon State Bar, which Charlie has recently challenged on behalf of our provisional Article 1, Section 1 government on Oregon, supporting and agreeing with Gary's brief on the Oregon judiciary, Article 7 amended. It contradicts our Bill of Rights and Oregon's Constitution, circa 1859, and the United States of America's Constitution, circa 1859. Does it fail at the first known defect? This goes back to Matthew Deedes, 2 books about Oregon. They both published the same lie. Amendment 13 XIII, Anti-Titles of Nobility. Remember Frank Benson, Secretary of State and Governor at the same time, which is a constitutional impossibility, gave us November 8th, 1910, Article 7 amended. And that has, to this day, no supporting evidence in fact. That has been acquiesced to and defaulted to by the state of Oregon, aka State of Oregon in all caps, a de facto subdivision of the United States of Washington District of Columbia, Inc. in some form since 1861. Did I mention we are no longer deceived? We also do stuff. We are pretty good at doing stuff, such as returning to a jure, constitutional, Republican form of government, Article 4, Amendment 4. These 2 documents for sure are in the contract between those that Oregon proposed in 1857 and the Constitution brought back. They have a reprint of the longhand 1857 version for sale, Secretary of State. What was actually ratified by the several states of the Confederation and Perpetual Union, styled the United States of America, is unobtainium from the State Archives Office of the Secretary of State. On 3 separate occasions in the flesh, we have made attempts with 3 secretaries of state and 3 under or deputy secretaries of state. Emails and phone calls abound. There is the 3rd document, Bouvier's Law Dictionary. We read in our Constitution's Amendment 7, then we define what suits in common law, courts and jury, and judges' law, and who defines the facts, and who can move to equity. SCOTUS in the United States federal district courts are not Article III courts, nor Amendment 7. Therefore, they lack the bona fides to try a man or a woman against the state. This also applies to the current state, county, and municipal and other courts, such as justice on Oregon or in the de facto Salem oligarchy. When taking one step at a time, knowing we are moving away from all that Kate Brown stands for and moving towards a constitutional Republican form of government, Article 4, Section 4. This includes all the political parties that subscribe to the de facto and that operated Oregon since the fraud of 1910. The ones that broke their oath, January 21st, 2021. The ones that participated in the homicide of Robert Levoy Finicum, rest in peace. The picture is clear. Without a proper oath and bondability to the proper constitution, with the laws of nature and nature's God included, moving through all that comes before us, returning to the path to our constitutional Republican form of government this year, 2025. The current step includes proper bona fides, as it is analog and not digital or de facto. It's jure and provisional until we have the office of sheriff properly occupied by our sheriffs. I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, to shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, shot him 3 more times.